Today we are going to present the San Antonio versus Rodriguez case, presented by Jenny, Clayton, Dailene, Peyton, and Chloe.
Overview of the case is going to give us some details about what the case entailed and why it was brought about. Parents who lived in a low-tax property district in San Antonio, Texas, created a united front to file a class action lawsuit against the Independent School District of San Antonio. The case was brought to the U.S. District Court for the Western District of Texas, being that it was in San Antonio. The three-judge panel had ruled that the Texas School District was unconstitutional under the Equal Protection Clause of the 14th Amendment. The state of Texas appealed to the United States Supreme Court, and the court overturned the decision. They filed it to the Supreme Court under Equal Protection Clause of the 14th Amendment, which states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States wherein they reside. No state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of laws.
These are the people who are going to be presenting each slide.
Society and Conditions and Circumstances in San Antonio, 1973, which is when our court case takes place. San Antonio in 1973 was home to many Hispanic American families. San Antonio had a population of about 700,000 people at the time of the court case. Families that lived and went to school in San Antonio School District had very low incomes. Many of these families were poor, leaving the school system in horrible shape based off taxes that were given to them. It should be noted, however, that San Antonio was granted a federally assisted urban renewal project in 1973. Circumstances that brought about the court case was found that students in Bexar County, which is the entire city of San Antonio, only received $37 per student, while Alamo Heights received $413 per their students. Students protested in 1963 for poor learning condition and inadequate facility, which jump-started the feelings that parents had towards the school system. On July 10th of 1968, Demetrio Rodriguez and a group of San Antonio parents filed a class action lawsuit on behalf of minority students from low-income school districts against the state of Texas.
Arguments that were utilized in court presented by Chloe Kingsley. San Antonio Independent School District had made an appeal to the United States Supreme Court. Charles Allen Wright, who represented San Antonio Independent School District, was the chief lawyer and had two main arguments. The first argument is that the Texas system does not disadvantage any suspect class. The system did not appear to discriminate any individuals classified as impecunious, nor did they occasion discriminations as an outcome of the wealth of families in a district. The resulting class cannot be suspect because the funding system disadvantages those regardless of their own individual income characteristics that live in a relatively low-income school district. Charles Allen Wright's second argument is that school is not considered a fundamental right under the United States Constitution. So the system is not impeding on any fundamental rights. The United States courts do not recognize it within the list of rights stated in the U.S. Constitution. The lower court's ruling of wealth being a suspect classification and education being a fundamental right under these circumstances is incorrect. Texas did not fail to demonstrate a rational basis for the state's financing system. In contrast, Arthur Gotchman represented Demetrio Rodriguez, one of the parents whose children attended an elementary or secondary school in Edgewood Independent School District in San Antonio, Texas. Gotchman had argued that The way Texas financed public schools had allowed for discrimination amongst the children in the poor school districts. The cause is due to Texas relying on local tax properties which benefit the wealthier school districts. This would violate the Equal Protection Clause of the 14th Amendment because of the significant interdistrict disparities in per pupil expenditures, resulting primarily from differing values of property. That would make wealth a suspect class, and it was also mentioned that funding should be more equal because education is a fundamental right, so they were impeding on a fundamental right. But this would demonstrate that Texas is not providing a rational basis for the state's financing system to public schools.
And public response. Thurgood Marshall provided a dissenting opinion on the case of San Antonio v. Rodriguez, which states, "The majority's holding can only be seen as a retreat from our historic commitment to equality of educational opportunity and as unsupportable acquiescence in a system which deprives children in their earliest years as a chance to reach their potential as citizens." Justice Lewis Powell was interested in the function of schools more than any other justice, and he believed that Rodriguez differed from the case of Brown due to the motive for alleged discrimination that was based on wealth. Chief Justice Burger agreed with the Texas brief and believed that the outcome of the holding would be reconstructing the local and state government system and therefore voted for reversal. Justice Stewart made a statement in which he believed that egalitarianism is not an obligation to the Equal Protection Clause and also voted for reversal. Stewart also made a statement that unless there is a specific class of people that is being discriminated, then the Equal Protection Clause does not apply, and Justice Rehnquist agreed with this statement and voted for reversal. Justice Blackmun's decision was based on the assessment that the Texas system provides adequate basic aid and voted for reversal. Justice White wanted to vote with a narrow opinion and agreed with the district court that if a state could not provide a way to equalize, then equal protection is denied and voted to affirm. Justice Douglas believed that the problem would not be solved by money and stated that the case was a problem of equality and voted to affirm. Justice Brennan believed that money was important and stated that if the state is providing education, the distribution of money should be equal and voted to affirm. In response to this case, as of today, every state has a school financing system equalization scheme. Only the state of Hawaii has embraced the other option in Rodriguez, which eliminates school districts in favor of statewide funding, and there is a guaranteed minimum level of spending for all districts and offered incentives to increase spending. Little was done to solve the equity problem, and there is a known gap between the richest and poorest school districts because no reforms limit the amount of revenue wealthy districts can raise.
Thank you, Jenny, for presenting that information. My name is Dailene, and I will be presenting Precedents and Public Opinion. In 1954, a young Hispanic girl was denied permission to enter an all-white school. Taking this situation to court, it was ruled unconstitutional to discriminate against students due to the fact that it violated the 14th Amendment. With this victory, the case known as the Brown v. Board of Education served to inspire change with the case we are currently covering. In 1973, the San Antonio v. Rodriguez case took place in Texas. Later, two cases were going to use its counterpart as a precedent, and in 1974, the Milliken v. Bradley case took part in Michigan. And in 1992, in Bexar County, Texas, the Edgewood v. Kirby case happened. This case talks about a suit that was filed against Governor Milliken. It was claimed that the Detroit public school system was racially segregated due to official policies. The court found that there was no evidence of a violation against the 14th Amendment. It was held that the school systems were not responsible for segregation across district lines unless deliberately engaged behavior in a policy segregation could be shown and proven. In the Edgewood case, 6 school districts, 25 families, and the Edgewood Independent School District filed a suit. They claimed that the state's constitution requirement that legislature provide an efficient and free public school system was violated by Texas school funding. Families and the system found that the state relied on local property taxes to fund and aid them. They found this very unequal because of a great variety on property values from various districts. Unfortunately, they did not win this time. Similarities found in these precedents were that they were unconstitutional because it violated the 14th Amendment. It was discriminatory because it was against students in poor districts and students of color. And lastly, everything in all of these actions were acceptable. Somehow, they found social segregation permissible. People reacted negatively upon hearing these news and thought that the government didn't care about their rights or education, nor the future of their children. They wanted to follow the example of the Brown versus Board of Education. However, their efforts were in vain because of the unfair setup the system put around communities. At this time, I'm going to hand it over to Clayton to explain the effects of these injustices in our daily lives today.
Effect on American society. In the immediate aftermath of the case, the rehearing is denied, and the precedent that is set is that the states will not be required to ensure any kind of funding equality. However, the wider consequences of this case is that there is a new level of scrutiny placed upon the states for their school funding models. Most states implement legislation to address inequalities in the years after. Following the decision, we generally see two patterns of solutions at the state level. One, state Supreme Courts rule on cases that are very similar to the Rodriguez case, and then prescribe solutions should state funding models be deemed unconstitutional. State legislatures then implement policy reforms. Two, state legislatures directly change the funding model without court direction. So for judicial change, in Ohio, property taxes were the dominant revenue source for school funding. This led to significant disparities between the funding of different school districts within the state. In 1997, Duralf v. State is brought to the Supreme Court of Ohio, and the funding model, and alleging that the funding model violates the Ohio Constitution's requirement of a thorough and efficient funding model for education. The court rules in favor of the plaintiff, and legislation is passed the following year to align with the requirements set by the court. So there's basically three different models that we're going to go into here for reducing inequalities. So first is foundation programs. States set a minimum amount per pupil, and localities and other state grants will pay for the rest. The second is power equalization. Each district spends as if they have the same property tax rates and revenue, and the state makes up the difference. This can lead to leveling down, which is when funding becomes more equal but lower on average, or it can lead to leveling up, where funding becomes more equal and greater on average. And then the third is full state funding. The school district model is practically abolished, and the state acts as one big school district instead for funding. For the funding model, it's used in 36 out of the 50 states. The state will set a minimum amount of funding per pupil that each district must reach. This model doesn't necessarily reduce inequality on its own, but it's almost always used in conjunction with other reforms. For power equalization in Georgia, the state analyzes per district property values and orders them into brackets. It then equalizes funding to the 90th percentile of that group and supplements the districts that can't reach that level based on property taxes alone. Analysis has shown that this program has led to greater equity in the Georgia schools. So for the third, full state funding, this only occurs in Hawaii. It's the only state that does this kind of model. The Department of Education within the state operates as the single school district for the entire state for funding. Analysis of the different districts is done to determine need, and funds are allocated based on a weighted student model. Property taxes are not levied to fund schools. Excise taxes and income taxes are instead used to be the major source of revenue used in the funding of public education in the state. So for reaction and legacy, the case is considered by many legal scholars to be one of the worst Supreme Court cases in the modern era. It created a situation wherein the federal government will not act in order to protect the basic rights to education, which most people agree are fundamental human rights. Despite this precedent, though, the case brought attention to the often neglected subject of school funding and inspired many state-level cases and later legislation, which did significantly reduce the inequalities and brought forward many reforms that were needed in the state school funding models in the U.S.
Thank you, Clayton, for presenting our last topic. I'm Darlene, and I'm here again to conclude this presentation with a few important highlights we found from this case as a whole. First, the 14th Amendment was multiple times violated, ignored, and overlooked. Second, we found that there was great inequality within the school district, as students did not get the same educational and financial opportunities other students did. Third, we saw that government policies had a huge influence with this system as they manipulated funding according to taxes and people's property values. Lastly, and probably most importantly, the theme and topic of education. We were brought this question: is education a fundamental right? As Chloe presented, some judges found that it was, and others not as much. And with that, we conclude our presentation. Thank you for watching. Here are our cited sources.